Good evening, Avinash ji.
Good evening, sir.
Good evening, sir. Good evening. Good evening. अविनाश जी शुरू कर सकते हैं अब. हेलो सर, कैन वी स्टार्ट नाउ?
Yes, yes.
Okay. So, good evening to all. We welcome all in our certificate course of GST 2014 litigation series. Now we are in the sixth day of GST litigation series. अभी लिटिगेशन का जमाना है तो लिटिगेशन सीरीज का भी बहुत इंपॉर्टेंट है हम लोग के लिए. सो टुडे वी हैव डॉक्टर एडवोकेट सीए आईपी अविनाश पोद्दार. Our eminent experts are currently practicing as an advocate in the field of indirect tax, commercial laws, and cyber crimes, having experience of more than 21 years of the professions. He's specialized in representing the litigation works pertaining for indirect taxations, appeared and argued before Honorable Supreme Court of India, various high courts, custom excise and service tax, commissioner appeal, settlement commissions. He's a special invitee of uh, Insolvency and Bankruptcy Committee of ICI for the year 2021-22, special invitee of GST and Indirect Tax Committee, contributor as a speaker. He has delivered more than 900 lectures all over India at various residential, regional, and national conferences of the ICA, ICSI, ICMI, and ICI with live webcast. So he has released various books as a co-authors, as the authors, and he's also authored a motivational books titled Unleash Your Hidden Potential, released internationally in July 2017. He is a professional and other membership of member of Bar Council of the Gujarat, member of Gujarat High Court Advocate Associations, life member of Gujarat Sales Tax Bar Associations, life member of Tax Advocate Association Ahmedabad, contribution to the society and others. So he has a very long list. So we welcome you, sir, in today GST litigation series. And we are very much opportunity. We have opportunity to listen Dr. Avinash Poddar ji. So it is a very insightful sessions. So we welcome you all. Just
Shall I begin?
just a moment, sir.
No problem.
So we are giving the e-memento to sir. Screen is visible.
No, it is not visible.
Just a moment.
Yes, now it is visible.
So e-memento to the sir.
Thank you very much.
So we hand over to proceeding to the sir for the deliberation.
Thank you very much, Anupji. At the outset, let me first tender the apology to the organizers because I was scheduled, if I'm not wrong, I was scheduled to speak on 9th of August 2024, but because of the throat infection, I was not in a position to speak. Rather, the throat infection still is continuing, but I am in a better position and hopefully I'll be able to deliberate for whatever time has been allotted to me. I would also like to thank Shubham ji and the entire committee, Tarun ji for coordinating, Shubham ji for considering and inviting me, and obviously the entire committee for considering me to be one of the speakers in this very apt series of the certification as well as the litigation. Now, the topic which is given to me today is search and seizure, and I also need to deliberate upon the detention and confiscations. Now, friends, we all are aware, and rather, I'm presuming I had a conversation in the morning with Tarunji, and I'm presuming that all the participants who are participating in this series are well versed with the provisions of the law pertaining to search, seizure, and detention, meaning thereby Section 67, Section 68, Section 129, and to some extent Section 130. Now, something which we all need to understand is that these are the provisions which needs factual interpretations. There are certain legal interpretations involved in some of the terms. Maybe reason to believe is one of the terms wherein the interpretation or jurisprudence needs to be applied. But at the same time, when it comes to search and seizure, there are many aspects which has to be looked into from the factual background. Therefore, what I'll try to do is I'll try to discuss the provisions very briefly and quickly, maybe in 15 minutes. Thereafter, some of the important aspects needs to be covered, or rather, I'll continue with the provisions as well as the aspects both in tandem, and I'll try to deliberate upon and complete my deliberation in 90 minutes, 90 to 100 minutes maybe, so that the participants can very well ask the queries, whatever they have in mind pertaining to this particular subject which is allotted to me, and that will add value to me also, and it will help me in learning further. With this endeavor, let me first and foremost start with section 67 subsection 1. Now, this is a term which has been introduced in GST law, I would say, for the very first time. All those who are practicing in income tax have time and again come across one term which is said to be the survey, which is not or which cannot be equated with an action of search. Similarly, now there is a term in section 67 which primarily deals with inspection, search and seizure, and therefore the term inspection comes into play. When we refer this term inspection, we cannot read this in isolation with the provision, and therefore the provision says that a person having a particular rank and a reason to believe that there is some action, some evasion, which is also intentional, then he may order the inspection to be conducted against the person against whom there is an allegation that he has evaded the tax intentionally. Meaning thereby, we need to understand first and foremost that if inspection has to be dealt with, we need to appreciate what does the term inspection means. And therefore, let me go back. I'll not be having any presentation. Please excuse me for that. But please be with me. I'm sure that we all will be able to appreciate the points which I'm trying to raise here during the deliberation. When it comes to the term inspection, there is a definition of the term inspection which is provided in the Black's Law Dictionary. And it says inspection means a careful examination of something. Now, please try to understand this definition very crucial, because the term inspection is not defined in GST law. And therefore, we need to borrow either from the dictionaries or from the instructions given in the CBIC, or maybe any circular or the notification, or maybe the settled jurisprudence. So therefore, the Black's Law Dictionary says that it means a careful examination of something such as goods to determine their fitness for purchase, or items produced in response to a discovery request to determine their relevance to a lawsuit. Meaning thereby, inspection is nothing but inspection of a particular item with a particular result in mind. Meaning thereby, whenever there is an inspection carried out under GST, the ultimate aim is to locate or to identify the leakage of revenue, and that too intentionally. If that is not there, then the provision of the law will not be made applicable. So therefore, now please also note down that there is also a CBIC FAQ which defines or which specifies the term inspection, and it says inspection is a new provision under CGST or State GST Act. It is a softer provision than search to enable officers to access any place of business of a taxable person, or also any place of business of a person engaged in transporting goods, or who is an owner or operator of a warehouse or a godown. Meaning thereby, the term inspection can be equated with the term survey under Income Tax Act. It is a softer version. The FAQ itself says, FAQ of the CBIC itself says that it is a softer version of the search, meaning thereby the harsh actions which is being taken during the course of search, or let me put it in this way, the harassment which is being caused to the taxpayers during the course of search is expected not to be there during the course of investigation, or sorry, let me put it, inspection. So inspection is much softer term, or rather it could be said that it is an action which may not have those repercussions as in case of search. So this is what the CBIC circular also says. Now let us go back to the provisions of the law. What does the provision says? Let me read the provision. I'm expecting everyone that they might be having some Bear Act in their hands. I'm reading from the Bear Act, and please be with me if the act is not there with you. I'll read very fast, and then we'll try to analyze the provision, and then we'll try to dwell upon some of the important aspects. Subsection 1, which deals with the inspection, says that where the proper officer, the term proper officer has been defined under GST law under clause 91 of section 2. It clearly says a commissioner or an officer who is authorized by the commissioner to perform certain acts. And when we read a circular, the circular of 2017, I think circular number 3, it says that for conducting a search or inspection, the proper officer would be additional or joint commissioner. So therefore, the law says where the proper officer not below the rank of joint commissioner has reasons to believe, meaning thereby the mandate or the warrant to inspect can be issued by a proper officer who need not be lesser than the position of a joint commissioner. And he must have reasons to believe. What reasons we'll discuss. But now here comes a very important aspect which clicks to my mind is, sir, when we compare this dual GST provision or the implementation, and when we compare the CGST brothers with the state GST brothers, they have a different way to look on or look up to the provisions of the law. And therefore, law says not below the rank of the Joint Commissioner. But I have come across certain notifications wherein the proper officer, who is certainly not below the rank of the Joint Commissioner, has passed a notification or issued a notification in the state laws and given the authorities to conduct the search, or rather to issue the warrant of search to the deputy commissioner, assistant commissioner, or maybe in some of the cases, the commercial tax officers. So here comes an important aspect to be discussed. One, when the law is very clear, it says where the proper officer not below the rank of Joint Commissioner has the reason to believe. So first and foremost, which is something I would say the most prominent would be a proper officer not below the rank of Joint Commissioner has to have the reasons to believe. Meaning thereby the person who is issuing warrant for search has to have the reason to believe and not any other person. So it cannot happen that Joint Commissioner was having the reason to believe. He has authorized by way of a notification that, okay, Assistant Commissioner can issue the warrant of inspection. And then the Assistant Commissioner, on the basis of reasons to believe of the Joint Commissioner, issues the search warrant or the inspection warrant. That is not permissible. So this I have come across at various states wherein the state authorities, state joint commissioners or additional commissioners have assigned these powers of conducting the inspection and search. See, there are two different aspects. One is conducting the search or inspection, and the other is having reason to believe and then issuing the inspection or search warrant. These two aspects are totally different. Search may be conducted by anyone, but the warrant can be issued only by the person who has the reason to believe, and the reason to be believed would be of a person or should be of a person who is not below the rank of the Joint Commissioner. That is what the statute says. So therefore, the question arises, what will happen in all those cases wherein the duties have been given to the Deputy Commissioner or Assistant Commissioner to conduct, and rather not only to conduct, but also issue the warrants for the search initiation, especially in case of the state tax authorities. I am of the view, this is my personal view, that goes contrary to what the law says. Although there is a law which says that there can be assignment of duties and which can be done by the commissioners or the proper officer. So meaning thereby a proper officer defined under clause 91 of section 2 certainly includes those persons who are appointed or who are assigned the task by the commissioner. But at the same time, we also need to appreciate that when the provision itself imposes a duty or encasts a duty on a particular post or a person, then that has to be discharged only by that person. And I can very well mention here that there is a judgment, we all are aware of that. There is a judgment of the Honorable Supreme Court during the, or in the GST regime, which is Radhakrishna Industries, wherein the same question went before the Honorable Supreme Court. Although it was in relation to section 83, but please appreciate section 83 deals with or gives the power to frame an opinion to the commissioner, and therefore it has to be framed by the commissioner. He can assign that execution, but opinion will have to be his. And therefore I am following the same analogy and saying that if law says not below the rank of Joint Commissioner, then it has to be a Joint Commissioner or an officer above the rank of the Joint Commissioner who has to have the reason to believe that the inspection is required. That is one. Now let us read further. Has reasons to believe that, clause a taxable person has suppressed any transaction Now, this is again something which is very, very important and pertinent because there are litigations qua this. The word used is taxable person. It is not registered person, meaning thereby, even if a person who is not registered, but if the officer not below the rank of joint commissioner has reasons to believe, then the action can be taken against the person who is yet to be registered or who is a taxable person. Because taxable person again is defined in law, which clearly says that a person who is registered or a person who is liable to be registered, meaning thereby the law is very clear that a taxable person may not have the registration, but he has to be liable to get himself registered. So law says a taxable person has suppressed any transaction relating to supply of goods or services or both, or the stock of goods in hand. So meaning thereby he has suppressed. Important is department while issuing the warrant for inspection has to place on record the reasons to believe that the taxable person has suppressed any transaction which is related to either supply of goods or services or both, or of the stock of goods in hand, or of claiming ITC in excess of the entitlement, or has indulged in any contravention of any provisions of this act or rules made thereunder, which makes it so broad that even any contravention of any rule can lead to, I'm repeating this, can lead to the initiation of inspection proceedings. But thereafter, certain words are used which are very relevant. To evade tax under this act, meaning thereby merely non-compliance of a provision of law cannot be a reason. I'm again with very strong frame of mind sharing this, that merely a non-compliance of a provision of law, although it is written, will not be leading to inspection of your premises under section 67(1), unless there are reasons to believe recorded by the authority or the proper officer not below the rank of joint commissioner, pointing out that there is a suppression of a transaction or the stock or the ITC has been excessively claimed, or there is a contravention to evade tax. Unless that is there, I'm of the view that the action cannot be initiated under 67(1) also. Now, when I say this, what kind of litigations are invited for? Nowadays, we have come across that even a short non-compliance, for example, non-filing of GSTR 3B, for example, non-filing of a reply to a particular notice, for example, not placing the signboard as per Rule 18, all these are considered to be a non-compliance under the Act or rules made thereunder. And when such non-compliances are there, can the department initiate inspection or search proceedings? They are doing it, but please bear in mind, friends, whenever any such action you come across, please challenge that action, saying that first and foremost, it is leading to suppression has to be proved by the departmental authorities. Two, it has to be to evade tax, and the word used is to evade tax, meaning thereby either the suppression of any transaction pertaining to supply of goods or services or both, or the suppression pertaining to stock of goods, or the suppression with relation to input tax credit availed, or the suppression in relation to any contravention or his indulgence in any contravention of provisions of the Act or rules made thereunder are to evade tax. Unless they are to evade tax, merely non-filing of a particular reply, merely non-filing of a particular return does not mean that it is to evade tax. And when the words to evade tax means, it is talking about the intention to evade tax. It is not talking about the short payment or non-payment of the tax. So therefore, this is something which is, as per my limited understanding, very, very important and crucial when we are dealing with the inspection, search and seizure proceedings. Now, friends, I appreciate that this is a session wherein the litigation is to be dealt with, but we have to appreciate that whenever the question of inspection, search and seizure comes, we have to be very thorough. I'm saying very thorough with the provisions of the Act and the jurisprudence and its applicability. Why I'm saying so? The reason is, this is an extraordinary power which is given under the statute. This is something which is said to be an investigative power, and an investigative power can be used to extract the situation wherein the tax has been evaded, not in a normal circumstance. So therefore, unless we are well versed with the provisions threadbare, it will become extremely difficult for us to handle the proceedings which are pertaining to, or which are the inspection, search and seizure proceedings. So therefore, this subsection 1, clause A we have read, or the another situation is, or any person engaged in the business of transporting goods, or an operator or owner of a warehouse or a godown or any other place in is keeping goods which has escaped, say, payment of tax, or has kept his accounts or goods in such a manner as is likely to cause evasion of tax payable under this Act. So therefore, any such act done by any person who is either storing goods as a warehouse owner, or an operator, or a godown where these stocks are recorded or saved, even the inspection can be taken against them. Now, please note the difference between clause A and clause B. Clause A, which deals with 4 situations, only the action of inspection can be taken against the taxable person. If I am not a taxable person, meaning there were, let's say I am a salaried employee, then the action cannot be taken against me because I was never required to take registration. But when it comes to storage of goods, or a warehouse or a godown or owner of the warehouse, then in these cases, it speaks about any person, meaning thereby the action can be taken by any person, even if he is taxable person or not. So even the action can be taken against the employees. Now, what will be the role of the proper officer? Let us try to evaluate that. In these 2 circumstances, first, taxable person, 4 situations. 2, the any person like transporter, warehouse keeper, godown owner. In all those cases, when the goods are kept which have evaded or which has escaped the payment of tax, then inspection can be taken against them. But the proper officer must have reason to believe. Now, when I say reason to believe, please read let us read first and then we'll go for reason to believe. He may authorize in writing any other officer of central tax to inspect any places of business. Now, please note this: places of business of the taxable person, or the persons engaged in the business of transporting goods, or the owner or operator of warehouse or godown or any other place. Meaning thereby, it can be conducted at any place. When it comes to taxable person, it has to be the place of business. Now, let us go to 2-3 very important aspects. First is reason to believe. When it comes to proper officer, I've already discussed that proper officer needs to be read in totality and therefore the reason to believe has to be framed by the proper officer, not below the rank of the Joint Commissioner. In these state cases, in the cases of state authorities, they have came out with a notification wherein they have authorized even the deputy commissioners or the assistant commissioners to issue INS 01, which as per me is not at all right interpretation of law, and that is without authority of law. And the moment it is without authority of law, the action can, or the challenge can be to the entire proceedings of search. So now let us try to dwell upon the jurisprudence which is laid down so far as the term reason to believe is concerned. Now, although the IPC is not there from 1st July 2024, but section 26 of the IPC was saying that a person is said to have reason to believe if he has sufficient cause to believe that the thing was there in existence, meaning thereby it cannot be on assumption basis. There has to be a strong evidential research, or maybe the documentation which enables the authority to determine that yes, this is the action which gives me a reason to believe that there was an intentional evasion of tax. So you can note down one citation. It is 1976, 103 ITR 606, Punjab and Haryana High Court. I'm repeating, 1976, 103 ITR 606. And it is HL Sibal versus CIT, wherein it is clearly stated by the Honorable Court. Reason is a statement of fact employed as an argument to justify or condemn same act. So it is a statement of fact which is employed as an argument to justify. That is something which is reason. When information is received, this is the meaning of reason which is given in HL Sibal. And therefore, when we read reason to believe, reason is one term and believe is one term. We'll discuss both the terms and the jurisprudence laid down under those terms, and then reason to believe. So reason is only a fact which we are using to justify the act. And when an information is received or facts are harnessed in support of an argument, the resultant effect assumes the shape of a reason. That becomes a reason. Facts which constitute the information must be relevant to the inquiry. They must be such from which a reasonable and prudent man can come to the requisite relief or conclusion. Material must have rational nexus of bearing to the reasons for formation of a belief. Now here comes something which is again crucial, and which is belief. So jurisprudence which is very important and laid down in Rich Udyog Network Limited. Rich Udyog Network Limited versus CCIT. The citation is 2016 2016 386 ITR 136 Allahabad High Court. 2016 386 ITR 136 Allahabad High Court. It deals with the term belief, and it says belief must be held in good faith. It cannot be a mere pretense or a doubt. Merely because you are having a doubt that there is a difference between GSTR 1, GSTR 3B, GSTR 2A, 2B, whatsoever, so many forms are there. And because of that, doubt that there can be evasion of tax, or there is some roving inquiry which is, or some roving information comes to you, and because of that you start believing that yes, this is a fit case for initiation of inspection. Sorry, that is not permissible. Reason being, belief has to be in good faith, and it cannot be on the basis of doubt. It has to be supported with some information in possession of certain documentation, and therefore it is said belief should not be based on mere suspicion, but must be based on information which is in possession of the authority who is authorizing the action of inspection or search or whatsoever. So therefore, the said information must be something more than a mere rumor, gossip, or hunch. It must form the basis on which the authorizing officer can have reason to believe that an action can be taken. So I hope that this judgment is certainly going to help us. I can see there are certain couple of the hands which are raised. I'll have question and answers in last 20-30 minutes. See, I'm speaking extempore. I do not have any material, so therefore I'll lose the link and the momentum. So therefore, please allow me. I'll take up all the questions which are there in last 20, 25, 30 minutes. Please allow me to deal with the discussion and deliberation. Once this is done, because otherwise I can lose my momentum. I'm sorry, I do not have a presentation. Reason being, I was not well, and then today the whole day I was in court, and tomorrow also I'm before the Supreme Court. So therefore, it was not possible for me to have this. I'm extremely sorry. So Rich Udyog Network Limited very categorically defines the term belief. So we have already seen HL Sibyl, who was discussing or which was discussing the term reason, and then Rich Udyog Network Limited, 2016 386 ITR 136 Allahabad High Court, which clearly discusses about the term belief. That when it will be said to be, or what is the term belief means. Now let us see how the term reason to believe has been dealt with by the courts, because that is something very crucial. Even if we are considering inspection as a provision, that is 67(1), or a search as a provision, in both the situations the term used is reason to believe, and therefore reason to believe is something which is extremely important to understand in order to understand the provisions of inspection, search and seizure. So the first citation or first judicial precedence as per me, which is Delhi High Court, 1969, 71 ITR 550. I'm repeating, 1969, 71 ITR 550, Delhi High Court, Balwant Singh versus R.D. Sharma. It says the existence of reason to believe is subject only to a limited scrutiny, and the court cannot substitute its own opinion for that of the officer carrying out the inspection. Court has no locus. Whatever you present as a circumstance, as a fact, supported by the documents, that would be considered, or that needs to culminate into reason to believe. Court will not add its opinion that whether the reason to believe was there or not, and therefore inspection must not lightly or arbitrarily invade the privacy of a subject. Before he acts, he must be, now this is important, before he acts, he must be reasonably satisfied that it is necessary to do so, but the decision must still remain his and not that of the court. So whether inspection is necessary, it all depends on the corroboration of the evidences which is there, which is leading or enabling the authority to believe that, yes, these are the sufficient documents, sufficient evidences pointing out the evasion of tax, not the non-compliance of a procedure without having the intention to evade tax. If there is an intention to evade tax and the documents which are corroborated are in existence, then it can culminate into the reason to believe. And therefore, if the grounds on which reason to believe is founded are non-existent or are irrelevant, difference between 3B and 2A, difference between 1 and 3B, that can never be a reason for inspection. Non-filing of a return, can it be a reason for inspection? The answer is absolute no. You can issue a summon to them. You can ask the person why he is not filing the return, but you cannot initiate an inspection. Therefore, it cannot be culminating into a reason to believe. So therefore, it is clearly stated by the Honorable Delhi High Court that if the grounds on which reason to believe is founded are non-existent or are irrelevant or are such on which no reasonable persons can come to that belief, the exercise of power would be bad, and then the court can interfere. For what? The court will interfere when the question is with regards to the legality and tenability of the action taken against the taxpayer or the assessee by the department, saying that we were having these reasons to believe, and those reasons to believe are coming out to be irrelevant or non-existent. It is also open to the court to examine whether the reasons to believe have a rational connection or a relevant bearing to the formation of that belief. So, how does it travel? First, maybe there is an information. That information needs to be culminated into a belief, and that belief has to be supported by the corroborative evidences. And when this belief is there, and the reason that belief gets culminated into a reason that why we should take an action. So this becomes a reason to believe that yes, on the basis of these documents, it comes out that yes, the action needs to be taken, or rather it is necessary to do so. Then only the inspection warrant under INS 01 has to be issued, not in the technical, mechanical, or what I can say, normal course of proceedings. No, that is not permissible. As and when, like, as you are issuing a summon, you cannot issue INS 01. It has to be supported, corroborated with both the aspects. One, a proper officer, not below the rank of the Joint Commissioner, has to do this. Two, there has to be a reason to believe. And third, something which is very important, that there is an evasion of tax. If any of these elements are missing, the inspection will become bad law. So this was the first jurisprudence which we have just discussed. The second is 2003, 262, 2003, 262 ITR 338 Calcutta High Court. आप ही के courts का है. And it's a very, very important principle which is let down. DDIT versus Mahesh Kumar Agarwal. Court cannot look into the aptness or sufficiency of grounds upon which satisfaction is based. This is not, the court does not have the locus of this. Satisfaction is subjective. If belief is bona fide and cogently supported, court will not interfere. Meaning thereby, you have to establish that the basis of your action is your reason to believe, and belief is something which is subjective. It cannot be a straight jacket formula that this, apply this, it will deem to be a reason to believe. No, that is not permissible. So therefore, it is something which is subjective, and therefore for each of the facts of the case, each of the different issues, different matters, you will have to apply this understanding of yours and corroborate the evidences in a bona fide manner in order to culminate that into a reason to believe. And once it culminates into a reason to believe, then only you can take an action, provided there is an evasion of tax. If there is no evasion of tax, I am of the belief that even having the reason to believe will not be helping you, or rather I would say enabling you to issue the warrant for inspection. Now here comes a very important aspect which again I would like to share with all of you. Please appreciate, friends, there is always a difference which we have noted time and again between the burden of proof and the onus of proof. I will not go into the onus of proof because that is not the topic which has to be dealt with by me today. But burden is something which I would like to touch upon. In the provision of section 67.1 or 67.2, the burden lies on the tax authority or a proper officer not below the rank of the Joint Commissioner. Therefore, he has to discharge the burden by recording the reasons to believe in black and white while issuing the inspection or search warrant. If he fails to do that, then I'm afraid that the entire proceedings will be vitiated. And when I say this, then the question which arises is he supposed or is he required to share the reasons to believe with the taxpayer? We'll deal with this question. No worries. I think in chat box also somebody has asked this question. So I'll deal with this question, not to worry. But the point which I'm trying to raise is the burden of proof does not get shifted. The onus gets shifted, meaning thereby the primary burden that there was a reason to believe that there is an evasion of tax because of certain non-compliances, because of the stock not being recorded, because of the supplies of goods or services, because of the ITC wrongly claimed, whatsoever is the reason, but the burden would be of the tax authority, not below the rank of joint commissioner. If he is unable to discharge that burden, meaning thereby if he is unable to record the reasons to believe, then the entire proceedings will be vitiated. And that is something which we need to look into whenever it comes to any assignment pertaining to inspection, search, and seizure. Now we have read that whenever it comes to the inspection, then it can be inspected at a place of business, which is defined in the law. I'll not go into that. Now, before discussing the reasons to believe and the whether reasons to be supplied or not, let us first go into section 67.2. Now, section 67.2 deals with the search. So when can a search be initiated? Now, please be with me for next 5 minutes and try to understand my perception of looking into the provisions of 67.2 as a student of law. सर हम जो बार बार देखते हैं कि डिपार्टमेंट इनिशिएट करता है सर्च एक्शन किसी भी पोजीशन में, मैंने आईटीसी गलत क्लेम कर लिया, मेरे सप्लायर ने कहा मैंने कभी गुड सप्लाई नहीं किए, मेरे ट्रांसपोर्टर के यहाँ सर्च हो गया, मेरे 2A में नहीं दिख रहा है. In all these cases, the search is getting initiated against the taxpayer. Question arises whether that is permissible, whether an authority can initiate a search action for such non-compliances or the queries. My limited understanding says that we need to look into the perspective from the, rather, I would say perspective which is coming out from the statutory provision. And if it is not covered within the statutory provisions, then any action leading to search under 67.2 needs to be termed as an illegal action and therefore is liable to be challenged. Therefore, let us first understand the term search. Again, I would say the term search is not defined in this law. And therefore, we need to refer into the dictionary meanings. And again, Black's Law Dictionary, I'll rely upon. And it says the meaning of search. It says an examination of a man's house or other buildings or premises or of his person, yani personal search also, with a view to discovery of contraband or illicit or stolen property or some evidence of guilt to be used in the prosecution of a criminal action for some crime or offense with which he is charged. So therefore, it clearly says that a man's premises can be looked into for identifying the illicit action or the stolen property to determine and to look into or to search into the stolen properties which are secreted. Now, what does the GST law says? Again, first and foremost, who can initiate the search or who can issue the warrant? Proper officer, not below the rank of the joint commissioner. Now, the question arises when he can do that. Now, please be with me for some time because this is something which is very important. My reading says that only 2 situations are specified in law which can lead to a search action. Only 2 possibilities. There is no third possibility. And those possibilities are where there is a reason to believe that the following is secreted in any place. Reason to believe. We have already dealt with the jurisprudence of that. So I'll not go into that. So reason to believe that the following is secreted at any place. 1. Goods which are liable for confiscation. 2. Documents, books, or things which are relevant for proceedings are secreted at any place. So therefore, search can be initiated only in these circumstances. Let me again go back. 1. Search can be done after the completion of inspection and when the joint commissioner or an officer not below the rank of joint commissioner is of the opinion that the inspection needs to be elevated into search, then the search can be initiated. यानी पहला तरीका क्या होगा? A first situation would be conversion of inspection into the search proceeding. Because during the course of inspection, you have come across some of those aspects which is leading to a reason to believe that the search becomes necessary, and therefore you can convert that into the search. Or the second situation is wherein there is a secrecy or secreted documents, books, or things. Those are secreted somewhere. Or there are goods which are liable for confiscation. So, अगर हम conclude करें, search cannot be for non-filing of returns. Search cannot be for illegal or a claim of ITC which you are not entitled for. Search cannot be on the basis of a statement given by your supplier that he has not supplied the goods. Search cannot be for all those situations. Search can be either it can arise out of the inspection being elevated to search, and that too when there are certain books, goods, or documents. Books, documents, books, or things are secreted at some place, or the goods which are liable for confiscation are there. Then the search can be initiated against, otherwise not. This is very clear mandate given by the statute, and therefore any action of search over and above this, because lots and lots of searches in a GST are taking place, and the reason of those searches not any of these, but the reason is claiming of wrong input tax credit, bogus invoicing, so on and so forth, and which as per me, if not falling within, if it is falling within any of these two, then it's okay. If it is not falling within any of these two, then those search proceedings are without authority of law and liable to be quashed and set aside, provided it is challenged before the honorable courts. सर्च के साथ एक और पावर आती है, which is seizure. Therefore, inspection doesn't have a power to seize, as per my understanding and reading of the law. If there is a, and therefore I always suggest, and you also, like we all the participants, everyone needs to be responsible enough to educate their own clients that whenever any such action gets initiated, we are supposed to look into INS 01 which has been issued, whether it is issued under section 67(1) or it is issued under section 67(2). I have come across certain INS 01s wherein there is nothing specified whether the action is under 67(1) or 67(2). Because the rule or the form says it is a pre-printed form, it says under section 67(1)/67(2). They will not click on anyone or they will not cross any of the sections, meaning thereby that clearly says, or clearly it can be understood as the issuance of INS 01 without having the reason to believe whether it is leading to an inspection or it is leading to a search, meaning thereby the entire proceedings from the inception itself is biased. Hence, INS 01 is a document which needs to be looked into, although they will not provide any copy of that INS 01 to any of the taxpayers. But we must look into that because they take our signatures into it. So therefore, we must look into under which provision it is done. And if there is blank or there is no tick under which provision we are supposed to ask that show us the authority and show us the reasons to believe under which provision of the law you are coming, because that will decide whether they have the power of seizure or not. If it is 67.1, they do not have any power of seizure. If it is 67.2, then only they have the power of seizure. But 67.2 has a very limited scope, I would say. 67.1 has a broad scope. Any indulgence, of the taxpayer in any of the contravention of the provisions of the act or rules made thereunder. So that becomes a broader perspective. But when it comes to search, it is very narrowed down, and therefore either there are goods, either books, things, or documents secreted at some places, or there are goods liable for confiscation secreted at some place. Only in these situations, or when 67.1 with reasons gets elevated to the search, only in these situations search can be initiated. Otherwise, there cannot be a search. So therefore, a very, very limited scope or narrowed down scope is there so far as search is concerned under GST. And therefore, we are supposed to look into 67.1 is there or 67.2 is there in IS 01. If it is 67.1, they cannot seize. If there is 67.2, then certainly they can seize. They can seize what they can seize. They can seize the goods also, books, good documents or things, whatever they get during the course of search, any of those things they can seize, which they presume or they believe will be relevant so far as their what I can say proceedings are concerned, or their enablement to determine the leakage of the revenue is concerned. So they can seize that. Accounts, registered documents, or any other of any other person produced before the PO, if the PO has the reason to believe that such person has evaded or attempting to evade tax, that can be seized. Now, let us try to understand the term secret, because see, please appreciate, and I'm for the sake of repeating and for the sake of convenience, I'm again specifying this with the abundant caution that search under GST has a limited scope. Authorities have a very, very narrowed down scope so far as search is concerned. For any of the non-compliances, they cannot initiate a search. They can initiate a search when there are certain documents, books, or things secreted, or the goods which are secreted are liable for confiscation. Then only the search can be initiated. And therefore, the term secreted meaning becomes very important. So one jurisprudence which is laid down by the Honorable Supreme Court, so far as the word secreted is concerned, is AIR 1966, Supreme Court 1209. I'm repeating, AIR 1966, Supreme Court 1209. This is something which is leading to a jurisprudence pertaining to the word secrecy or secret. Durga Prasad versus HR Gomes. When it comes to section 105, it deals with section 105 of the Customs Act. Secreted means documents which are kept not in normal or usual place with the view to conceal them. So if an officer comes and he is finding the documents on the table or where other documents are kept, or in the normal shelf wherein the documents are kept, rest of the documents are kept, that cannot be termed as secreted. Secreted has to be when it is placed at an unusual place to conceal or not to get extracted in normal means. That is something which is secreted, and it may even mean documents or things which are likely to be secreted. It includes documents or things which a person is likely to keep out of the way or to put in a place where the officer of law cannot find it. What can be called from an assessee in the normal course should not be recovered from him under the search proceedings. Now, this is the important line which I was pressing upon. If you can issue a summon to me and ask for the returns not filed, if you can issue a summon to me and ask for the difference between GSTR 2A and 2B, or 2A and 3B or 1 or 3B or whatsoever. And where is the question of initiating a search and seizing the document? Because it cannot be termed as secreted. Secreted has to be that with the intention to conceal, with the intention that nobody at the officer cannot find it in the normal procedure, would lead to the term secreted, and therefore the discharge of the burden again would lie on the department. They will have to establish that the goods, books, or things were secreted. Unless they are able to discharge that burden, I'm of the view that the search action, if initiated, needs to be vitiated. It has to be declared as without authority of law. Now, so far as now we have dealt with the inspection provisions and the search provisions. Now, when we read secreted, and what we have done, read is goods liable for confiscation 1, documents, books, or things. So here comes an important point, which has been adjudicated by the Honorable Supreme Court also, but it is something which is very relevant, and therefore I would like to touch upon that, is can cash be seized? It says goods which are liable for confiscation. So for confiscation, the seizure is mandatory. The first goods can be seized and then it can be confiscated. Then it comes to books, then it comes to documents, and then it comes to things. So it is not, cash is not goods. It is not books. It is not documents. Can it be termed as things? So there was a judgment which was saying that it is getting covered into things, and therefore cash can be seized. It was a judgment of Kanishka Mata of Madhya Pradesh High Court. Thereafter, there was a judgment of Shabu George of Kerala High Court, which travelled up till the Supreme Court, and Supreme Court has agreed with the judgment given by the Kerala High Court, and Kerala High Court has clearly said that under the aegis of GST, a cash cannot be seized because it is nowhere covered under any of these clauses. And unless it has the intention of pointing it out to the income tax officer, the GST officers cannot step into the shoes of an income tax officer. Therefore, the seizure of cash is not permissible. And this traveled up till the Honorable Apex Court, and the Apex Court has denied to interfere in the judgment of the Honorable Kerala High Court. And now, as per my limited understanding, that becomes the law of the land, that cash under GST cannot be seized. Now, let us move further. When it comes to seizure, the question arises, if it is to be retained, for how long it can be retained? So the simple answer in these books is, in the statute book, is that so far as or as long as it is necessary for the examination or the inquiry, it can be seized and retained. The moment your inquiry gets completed, you need to return it back. Now here comes another practical aspect. बहुत सारे लोग ये क्वेश्चन राइज करते हैं कि सर, my statement which was recorded has not been supplied to me. I am in requirement of my documents for the purpose of filing of return, which has been seized by them. They are not giving those documents back. So there comes two important aspects to be kept in mind. One is relied upon document and non-relied upon documents. They can collect any document from you. They can take any statements of any person. If they are relying upon all those documents, they will provide those relied upon documents along with the show cause notice. But if they have collected any documents from your place and which they are not relying upon, they are supposed to return those documents in original as per the statute. Henceforth, the documents relied upon will be supplied to you along with the show cause notice, and the documents not relied upon, which were collected or seized from your premise, would be returned because they are not relying upon, or once the examination is over, they cannot be retained further. So far as the statements relied upon are concerned, please appreciate, let us presume they have taken a statement of 20 people, but they are relying only on the statement of 2 persons. So they are bound to supply the relied upon documents or the relied upon statement of those 2 people on whom or on whose statements it is being relied upon. If they are not relying upon on the 18 balance persons, then it may not be supplied. So therefore, there is no condition to supply the statements being recorded during the proceedings. So retention, how long? We all are now clear that till it is necessary for the examination or the inquiry which is being carried on. And when it has to be returned, the goods, documents or things which are not relied upon in the notice has to be returned within 30 days of the issuance of the notice. So the moment you issue a show cause notice, if it is relied upon, you will supply those documents which are relied upon along with the show cause notice. If it is not relied upon, then you have to return all those documents within the period of 30 days of the issuance of the show cause notice. The question arises when the notice has to be issued. Now, here comes a very, very important catch. The notice, if you want to issue for confiscation, has to be issued within a period of 6 months. As per section 67, subsection 7. I'm reading for the convenience of all of us. Where any goods are seized under subsection 2 and no notice in respect thereof is given within 6 months of the seizure of the goods shall be returned to the person from whose possession they are seized. And that 6 months period can further be extended for a period not exceeding 6 months. Therefore, maximum period for issuance of the notice for confiscation of the seized goods, it does not apply to books, things, or documents. It applies only to goods which are seized during the course of search. So the goods which are seized during the course of search, the notice pertaining to those goods with relation to the what I can say, the confiscation has to be issued within a period of 6 months, maximum within a period of extended period further of 6 months, that is 1 year. If that time lapses, then those goods which are seized has to be returned back to the taxpayer or to the person from whom those goods were seized. So this is something which is very important. There is a lot of litigation which is going on with relation to this point, that they have initiated a search, they have seized certain goods, and now even after a period of 1 year or 2 years, they have not issued any notice of confiscation under 130. And in absence of those notice, there is a settled principle, and there are a number of judgments even under GST, which says that if that statutory time limit or statutory life is over, then the goods which are seized are liable to be returned back to the person from whose possession those goods were seized. Please keep this in mind. This is again a very litigative point, wherein a lot of litigation is going on. We'll come to section 129 and 130 also. In some time, we will touch upon that also. And then it comes to a provisional release of the goods also, which is there in 67(6). If there are certain goods seized, those are of importance to you, then you may not wait for 6 months for issuance of the, for returning back of those goods or the notice or confiscation or whatsoever. You can very well apply for the provisional release of those goods. And provisional release can be done upon the execution of a bond and the furnishing of a security. So bond can be for the value of the goods, and security should be for the tax which is involved. So if there is a 1 crore rupees the value, 18 lakhs is the tax, then 1 crore bond and 18 lakhs security. Security can be by way of the bank guarantee or any other security. So this can be done on execution of bond and furnishing of security, or the payment of tax and interest and penalty. Either of the options can be exercised. Then 67(2) also has a proviso which says that if it is impracticable to seize the goods and take it away, then in that case you can have the symbolic possession, and you can issue INS 03, wherein you can instruct the taxpayer not to remove part with or otherwise deal with the goods except the prior permission. So in this also, I would like to share one jurisprudence, which is Om Prakash Jindal versus Union of India, 1976, 104 ITR 389, which deals with the term impracticable. It says when the nature or location of the property found on search, which is reasonably believed to be undisclosed property and does not allow, or the circumstances does not permit the immediate seizure of the same, the order of detention cannot be issued for the purpose of finding out whether the goods are seizable or for further inquiry. So therefore, something which is very important is that you cannot issue the orders merely because you are not in a position to decide whether the goods are liable to be seized or not. If you are very clear that the goods are liable to be seized or confiscated, then only during the course of such action you can seize those goods. Even you can have the symbolic possession, wherein you can issue DRC 0, INS 03, saying that you should not part with these goods. Now, let us now have touch upon whether assessee is entitled to a copy of reasons recorded for issuing a search warrant. Because we have read 67.1, 67.2, both says reason to believe. I'm not going into other provisions of the section 67 or because I have already presumed, or we have already discussed in the morning also, that the participants are already well read. So I'll not go into that. The mere pointers which I wanted to touch upon, I've touched upon. Now, the important jurisprudence which I want to touch upon is that most of the times this is a query which is raised. कि सर ये जो reason to believe है ये हमें नहीं दे सकते क्या? Why they cannot provide, or why they should not provide, or why they should provide. So it has been dealt with by the Honorable Supreme Court in Spacewood Furnitures Private Limited, 2015, 57 taxman.com, 292 Supreme Court. I'm repeating, 2015, 57 taxman.com, 292. It says reasons or recording of reasons is necessary so as to ensure accountability and responsibility in the decision-making process. Number one. Number two, however, that by itself would not confer in the assessee a right to communication of the reasons for the belief at the stage of issuing of the authorization. Any such view would be counterproductive to the entire exercise contemplated in the search provisions. And therefore, it is only at the stage of commencement of the assessment proceedings after completion of the search and seizure, if any, that the requisite material may have to be disclosed to the assessee. Question arises, does it apply under GST? Reasons to believe. So therefore, one thing is very clear, reasons to believe has to be recorded by an officer not below the rank of Joint Commissioner to initiate any action of inspection or search and seizure. But it is not supposed to be disclosed to the assessee. It can be disclosed at the end of the proceedings when the assessment is being framed. That is what the Honorable Supreme Court in Spacewood Furnitures have clearly held or let down. Under GST, the show cause notice may be issued after 3 years, after 4.5 years, till 4.5 years. And therefore, something which is very important is the reasons to be believed which is recorded need not be supplied to the taxpayer is something which is settled. But something which is also settled is that we can approach the High Court and we can, if we have a reason to believe, rather, I'm talking about the taxpayer. If we are very clear that there cannot be a reason to believe, therefore the assessee, the assessing officer or the authority cannot be having any reason to believe to initiate the action of search under section 67(2) or inspection under section 67(1), then we can very well approach the court and we can request the court to ask for the reasons to believe to be supplied in a sealed envelope to the court of law. And please bear in mind that the court, if directs, and if we are able to make the case strong, and if the court directs the authorities to provide the reasons to believe in the sealed envelope, then they will be supposed, or they are mandated, or they will be required to provide the reasons to believe in the sealed envelope to the court. And then on the basis of reading those reasons to believe, the court may decide further that whether the action of search was legally tenable or not. Therefore, if you are very strong in your view that there cannot be a reason to believe leading to the inspection, search and seizure, you may approach the Honorable Jurisdictional High Court under Article 226, asking for them to supply the reasons to believe to the court, and then the court may decide whether those reasons to believe are substantiated and supported by the corroborative evidences leading to that reason to believe, or it is merely on the basis of a suspicion, rumor, or any, what I can say, abrupt information. Now, next question. This was the question that whether the reasons of the belief has to be supplied. Space, wood, furniture is the decision of 2015 of the Honorable Apex Court. Next question is whether illegal search vitiates seizure and subsequent proceedings. If the search is declared to be an illegal search, then does it vitiate the seizure and the subsequent proceedings? Again, there is a precedent. Again, there is a jurisprudence led by the Honorable Supreme Court in AIR 1963, Supreme Court 122. I'm repeating AIR 1963, Supreme Court 122, Radhakrishnan versus State of UP. It says, even if the search is illegal, the seizure of articles and further trial is not vitiated. If such provisions are violated, only the following consequence may arise. The person whose premises is sought to be searched can at the best resist the search if he finds it to be illegal. And because of the illegality of the search, the court may be inclined to examine carefully the evidences regarding the seizure. So it may be further investigated or further examined by the court. If the court finds that there is no reason to believe, and then the court may look into or examine that whether the seizures which were done during the course of the search, which is initiated with no reason to or proper reason to believe, then the court may examine that whether the seizure was necessary or not. And another is 1983 12 ELT 122 Kerala High Court. This is again important judgment because ये बहुत लोग हम लोग claim करते हैं. And it says that on examination, if the evidence regarding the seizure of the articles is found to be satisfactory and acceptable, it will not be in the interest of the justice to ignore altogether that evidence. So therefore, if something which is seized is relevant or is important and is liable to be seized as per the examination of the court, then even if the search proceedings are illegal or declared to be illegal by the court, the seizure will remain legal. That may continue. And therefore, this is something which, again, I would say is relevant, and we have to keep this in mind while dealing with the judgments or the situations of the search and seizure. Now, in next 10 minutes, I'll try to touch upon section 129 and section 130, which again is very, very crucial because I've been asked to discuss with the detention also. See, please appreciate section 68 requires certain documents to be carried. And then article rule 138 specifies which documents to be carried. So these are e-way bill and the invoice, which are supposed to be carried along with the conveyance. If these are not there, then it will be treated as the violation of the provisions of the law, and section 68 gets violated. And when section 68, or let us put it in this way, when any provision gets violated, it gets culminated into the term, or it falls within the term offense. And when it falls within the term offense, then there is a leviability of penalty for the offense. Therefore, The moment it is established that the documents which was supposed to be carried as per the provisions of section 68 read with rule 138 or 138A, important would be to check whether the offense has been done. If the offense has been done, then the penalty under section 122, 129 becomes invocable. And therefore, let us read section 129 heading first. It says detention, seizure, and release of goods and conveyance in transit. We all know that there is a substantial amendment, very important, prominent amendment done under section 129 and section 130. Prior to this amendment, section 129 and section 130 both started with a non-obstant clause, notwithstanding anything contained. So therefore, there was a judgment, or there is a judgment of synergy forticem. Although the time will not permit, I'll not go into the discussion of that. But synergy forticem was a judgment wherein the Honorable Gujarat High Court have very categorically held that since both section 129 deals with the detention, seizure, and release of the goods and conveyance in transit, and section 130 deals with the confiscation, both can be applied simultaneously also. But there were certain conditions when both can be applied. After that judgment, the amendment came in the law, wherein the law was amended to an extent from 1st January 2022. The law was amended to an extent that the non-obstant clause under section 130 was removed. Section 130 now reads with where any person. Earlier it was notwithstanding. So therefore, non-obstant clause has been removed, and therefore, to some extent, I would say that synergy forticem may not be a good law now, looking to the current provisions of the law. Number one. Number two, section 129 deals with the detention, seizure, and the release of the conveyance or the goods when in transit. And section 129, when you read today, it deals with the total or the complete code in itself, because now it says that there has to be a penalty for the purpose of release to the extent of 200%. If the owner comes forward, if it do not come forward, then it is 50% of the value. And then clause C says that he can furnish a security equivalent to the amount payable under clause A or clause B in such manner and form as may be prescribed. So still there is an option to furnish the security which is equivalent to that amount and get the release of the conveyance or the goods. Thereafter, it also provides that a notice has to be issued within a particular time limit, and it has to be adjudicated within a particular time limit, which is there in subsection 3 of the law. Amended law, I would say. Prior to that, there was a provision of subsection 2, which is now omitted. Subsection 2 clearly said that 67 was supposed to be used for the purpose of release of the conveyance or goods. When we were reading it along with section 67, meaning thereby this seizure was done under 129, read with section 67, read with section 68 because of the non-compliance under section 68 documents. And therefore, the release would be under section 67, subsection 6. जो हमने पढ़ा था, value of goods का bond and value of tax का security. But now that provision has been deleted, and therefore the release itself is now in clause C, which says that you can get it provisionally released. You can get it released by making the payment of 200% of tax or 50% of the value of the goods, or if not both, then providing a security to the equivalent value. Notice has to be issued within 7 days, and it has to be adjudicated thereafter. If the adjudication is not done, then in that case, or even after adjudication, if you fail to make the payment, then there is a power which is given to the authority to dispose of the goods which are, or the conveyance which is under the seizure. meaning thereby they can conduct an auction and dispose it off. Prior to this amendment, there was a provision that if within 14 days I fail to make the payment, then it will be automatically confiscated and it will go to section 130. Now let us come to 130 and then we'll have a discussion on one or the 2 points and then we'll open up for question and answers. Section 130, if we read cautiously, now does not have the non-obstant clause. It reads that where any person. And then there are 5 clauses, which says if any person indulge into any of such activities, then it will be liable for confiscation and liable for penalty under 122, which speaks about the 100% of the penalty. If we read this, then clause 5 becomes important. It says uses any conveyance as a means of transport for carriage of goods in contravention of the provisions of this act or the rules made thereunder, unless the owner of the conveyance prove that it was so used without the knowledge or connivance of the owner himself, his agent, if any, and the person in charge of the conveyance. The point which I am trying to draw here is, and the point of discussion today is, if an action of detention is taken under section 129 against a taxpayer, can the department initiate the action of 130 also for the same transaction? Meaning thereby, let me give an example. Today it is 12th of August. On 12th of August 2024, there is a detention. There is an interception and detention of your conveyance and goods. Now, after the interception, let us take an example not of 12th but of 10th of August. तो 10th अगस्त को उन्होंने आपकी गाड़ी रोकी है and रोक करके उसको intercept करके MOV1, MOV2, all those documents they've issued. On 12th, that is today, 12th of August 2024, in spite of using section 129 and issuing a notice under section 129, they have issued a notice under section 130, MOV10 आपको issue कर दिया. Meaning thereby, in spite of levying the penalty under section 129 for the non-compliance under section 68 read with 138 rule, they are now saying that we are confiscating the conveyance and the goods which were intercepted under section 129. Can they do that? My limited understanding says that it is being tested by the Honorable Gujarat High Court. There is a bunch of petitions which are laying, wherein the same has been challenged that if you initiate an action under section 129, you cannot initiate a section under 130, because section 130 to be initiated, first and foremost, there has to be a seizure. Unless something is seized, it cannot be confiscated. Under section 129, it does not speak now about any kind of seizure. It says it is liable for detention or seizure, and after detention or seizure shall be released. So now that 67(6) provision has gone from section 129, it becomes a code in itself, because it says, where is the question of confiscation? If I'm seizing something and if you are not making the payment after the order within 15 days, I'll dispose it off. It can be disposed under sections 129 subsection 6. So where is the question of confiscating those goods against which the action has been taken against section 129? So therefore, the question which I would like to discuss here would be, if an action has been taken on 10th of August 2024 in my example, wherein the interception has been done of my conveyance or goods, and thereafter now on 12th of August 2023, when you were supposed to issue the show cause notice for the detention or for the seizure under section 129, in spite of that, you are saying कि आपका supplier या आपका supplier is found to be bogus. His registration is found to be cancelled, and because of that, we are covering you under section 130. And since you are being covered under now 130, we are issuing MOV10, which is section 130 notice, and therefore you are liable to, or your goods is liable for confiscation and the conveyance is liable for confiscation. The question arises whether it is permissible. My limited understanding says it is not permissible. The moment you take action against section 129, if you take an action under section 129, you have to read the provision of section 129 in totality. And therefore, it being a code in itself, I'm of the view it cannot lead to section 130. For that, you will have to initiate section 130. And for initiation of section 130, you will have to first seize. And for seizure, you will have to first initiate the search action. So therefore, something, a conveyance or goods, when it is during the course of transit, when it is intercepted and detained or seized, it has to be released under section 129, subsection 1, clause C, clause A, B, or C, or it has to be sold or disposed of as per section 129, subsection 6. You cannot convert that proceeding under section 130. For an action to be taken under section 130, you will have to first establish that I fall within any of these 5 criterias. And if I fall into any of these 5 criterias, first you will have to initiate the search and seizure, and then only you can confiscate. Without the search and seizure under section 67, I am of the view that section 130 cannot be invoked. For section 129 action, the section 129 is in code in itself, and therefore the disposal has to be under section 129. It cannot result into section 130 proceedings. That is what we are arguing before the Honorable Gujarat High Court. More than 100 petitions are pending, and the hearing is going on. And let's see what is the decision of the court. But this is how we read the law, that 130 should not be invoked unless there is search and seizure. And when it comes to section 129, it is a complete code in itself. And when it is a complete code, then you cannot come out of that code and now allege that your supplier has supplied in contravention of the provisions of the law, and therefore it is liable to be confiscated, or the goods are liable for the confiscation because you fall into clause 1 to 5, any of the clauses of section 130, section 130, subsection 1. So this is how we read when we read this in totality with section 67, because only section 67, subsection 2 deals with search and seizure. And unless there is a seizure, the confiscation is not permissible. And confiscation is permissible only under section 130, which is now not a non-obstant clause, which was dealt with in Search Verticam, wherein we have seen that a simultaneous proceeding or a parallel proceeding of section 129 as well as 130 can be initiated. Now, since the amendment is there and the non-obstant clause has been deleted from section 130, and if I take an action under section 129 which deals with a non-obstant clause, and also since 129 is a code in itself, a complete code in itself, I'm of the view that once section 129 gets initiated, section 130 is not permissible in law. Friends, this was the topic. This was all about the topic which was given to me, the search and seizure, and to some extent the interception and detention of the goods and the confiscation thereof. Although there are certain jurisprudence under GST, I would like to touch upon one or two judgments. I would say Sabu George I have already touched upon. Another very important aspect is that can they recover during the course of search? Because this also they are implementing time and again, that they are forcing us to recover. They are forcing us to pay, otherwise they will arrest. They have the power of arrest. So what they will do, they will come to us and then they will start saying that as per us, the liability exceeds 5 crores. And since it exceeds 5 crores, either you pay or otherwise we'll arrest you. The question arises, can they do that? So for that, there is a circular also. And I'm very happy to share that there is an, I argued one matter in 2021, Bhumi Associates, which molded them or which mandated them to issue a circular saying that there cannot be any recovery during the course of search, barring few situations, which certainly is not in link with the instructions which were given to the CBIC by the Honorable Gujarat High Court. Then there are other high courts, like in Delhi High Court, Vallabh Textiles, it is now a settled law, which says that if there is any coercive recovery during the course of search, it is bound to be refunded back because they cannot act as a recovery officers. They are merely visiting the premises under the authorization to conduct an inspection or a search. And the The duty which is encasted to them is to find out, to locate the evasion of tax, if any, on the basis of the documents, goods, books, or things which are secreted or liable for confiscation. If they are not able to point out anything, then in that case, the recovery cannot be done in any circumstance whatsoever. Even if the person is voluntarily willing to pay during the course of such, that also need not be accepted by the authorities. This is what has been instructed in Bhumi Associates and followed in Vallabh Textiles. Vallabh Textiles, the Honorable Delhi High Court has clearly said whatever has been recovered coercively during the course of such needs to be refunded back to the taxpayers. So therefore, the another question which I would like to touch, or I wanted to touch upon, was that can a recovery be initiated during the course of search? And to my understanding, the answer is no, it cannot be done. With this, I would like to thank once again the organizers for bearing with me, for giving me this opportunity. Although I was scheduled to speak on 9th of August 2024, but unfortunately, because of my throat infection, I could not speak. So I'm extremely, extremely grateful to Shubham ji, to Tarun ji, and to the entire team, Anup ji, for considering my request and bearing with me and giving me an opportunity today to deliberate on the topic which was allotted to me. I'm extremely thankful to each of the participants for the patience hearing, and certainly we'll be looking forward for learning more from you all in the manner of queries that you ask, or in the shape of the queries being asked to me. Thank you. Thank you very much. Over to you, Anupji.
Thank you, sir. Now, sir, we can take the question answers. So first questions in the chat box is Ranveer Singh Kapoor. Sir, in INS 01, they sometimes mention, just a moment, sir. First question is from Ranveer Singh Kapoor. Sir, can we ask for the copy of reason to believe?
I've already shared this. Spacewood furnitures, I've already dealt with reason to believe that it cannot be supplied. But yes, we can approach the court and ask the court uh, for the reason to be supplied to them, reasons of belief to be supplied to them. That is possible, but we as a taxpayer cannot ask.
Okay, sir. Sir, if they have INS 01 for Firm A, can they assess document for sister concern Firm B running from the same premises as registered address?
Technically not, legally not, but practically they are doing it. Legally they cannot do it because they have no mandate to inspect the Firm B. So therefore they cannot do that. But unfortunately, practically they are doing it. So you can challenge it.
Okay, sir. And CA Anu Sharma circular number. Can you?
Yes, I'll have to look into that circular number. I'll surely be sharing. I'll share with any of the members of the committee.
Right, sir.
That can be touched.
Right, sir. Any other question? Is PD Rungta and Company GST team, is there any difference between search and inspection? I think it is already covered.
Yes. There is a big difference.
Yes. Okay. So any no questions in the chat box? Any audience want to ask any other question? Please raise your hand. So, sir. C. Anuj Sharma. Sir, in case of someone under section 70, they give vague reasons. What can we do in that case?
Sir, please appreciate when it comes to summon, they have broad powers under summoning section. But as we all know that it has to be read with a particular inquiry. Generally, they are not mentioning those inquiries details, or they are asking for a, let's say 2017 to the say like 2022 the 2024 तक के सब records ले आओ. So my submission, my only submission would be that in all those cases, please reply back to the summon saying that it is without jurisdiction and it is vague to this extent. Kindly remove the vagueness or kindly explain what exactly you are looking forward for. If you can do that, please do that. They are bound to provide the details as per your willingness, because a vague summon is not legally tenable in law.
Okay, sir. So any other question from the audience? Sir, actually, we have covered all the questions in the chat box. And
Let me just mention the circular number. I'm looking forward for that circular number. It is not circular, it is instruction.
okay,
1 of 2022-23, 25th May 2022. That is an instruction which has been dealt with in Vallabh Textiles.
right, sir.
That can be seen, and I think there was a circular also. Just give me 1 minute.
Yes, sir.
This is an instruction only. Please refer this instruction, 1 of 2022-23, wherein the subject is deposit of tax during the course of search, inspection, or investigation. So deal with this. This deals with the particular issue, and it
Okay,
also
sir.
1 of 2022-23, 25th May 2022. Please refer this.
Okay,
And
sir.
also the order of Bhumi Associates.
Sir, as you said, as under section 67, where the proper officer not below the rank of joint commissioner, right, sir? So when somebody has come in the premises, right? So what document we should ask from that person actually?
INS 01. INS 01
I
is the authority.
so
This is
INS 01. Okay, sir. But how can we determine it is? Is officer is issued by not below the rank of joint commissioners?
INS 01 is an authority which is given by the person who is issuing it. So therefore, it will be signed by the authority who has to be not below the rank of the joint commissioner.
Okay, sir. Okay. So, CA Manish Jha, can the officer direct do search or it will be conversion of inspection into search only?
No. Direct search can be done in that situation wherein the goods are liable for confiscation, or there are books, documents, or things which are secreted. In that situation, the search can be done directly, but there has to be a reason to believe. They need to say, for example, just give me an example. I am giving an example. For example, they have a reason to believe that there are certain documents which are secreted at the accountant's premises. So then they can search the accountant's place, because that they were having the reason to believe that the documents were secreted. And we have already discussed that what does the term secreted means. The term secreted does not mean in the normal course. It means that to conceal something, you are putting a document at an abnormal place with the intention that these documents should not be found in the normal course. So that is secreted. So if the documents, goods, books, or things are secreted somewhere, then certainly the search can be initiated directly.
Okay, sir. So one query from Subham: tax and penalty has to be paid before they return back the confiscated goods.
When it comes to confiscated, it is not the return back of the confiscated goods. It is basically the confiscation fine. But seized goods, yes, the tax and penalty, rather it is not tax now. After the amendment from 1st January 2022, it is 200% penalty, not the tax.
Okay, sir. CA Manish Jha, can they come to CA office also if client says our documents are kept at CA office?
Yes, they can do that.
Okay, sir. Okay, sir, we have covered all the questions in the group, sir. Thank you, sir, for the insightful sessions on search and seizures and detentions. Sir has done the clause-wise analysis of section 67, has also covered 129 and 30. And there is a CBIC FEQ for the inspection. Sir has mentioned inspection is much softer words than the search. And sir also covered judicial pronouncement for the inspections and search and the detentions. So thank you very much, sir, for the insightful sessions, and thank you for all the audience for the patience hearings. Thank you very much.
Thank you so much, sir. Thank you.
Thank you, sir.